and welcome. I'm Kelly Weiss, Executive Director of Marketing and Communications at UC Davis Law. And thank you all for joining us as a continuation of our Racial Justice Speaker Series and a special endowed lecture that Dean Johnson will tell you more about. I'm going to give a few house rules before we get started. As you know, we are on Zoom. So once we have the end of our presentation from Professor Citron, we will be taking questions. Those questions will be directed to me through the chat, and then I will then ask the professor for her responses. We will be sending out, or I should say, posting a video of this lecture on our website, and you can expect that in the next few days. And I also want to mention for any of our attendees who have requested MCLE credits, we will send those to you via email within the next week. So now I will turn it over to Dean Johnson.
Thank you all for joining us today. I'm Kevin Johnson, Dean of UC Davis School of Law. And we are very fortunate today to have Professor Danielle Citron from the University of Virginia School of Law to deliver the James B. McClatchy Foundation Lecture on the First Amendment. Now, the James McClatchy Foundation, previously known as the Central Valley Foundation, was established by the late James McClatchy, longtime publisher of McClatchy newspapers. The foundation supports organizations and education programs dedicated to, among other aims, protection and education and promotion of First Amendment rights. I want to give special thanks to Susan McClatchy and our alumnus, Steve Boutan, class of 1972. Steve was a former foundation board president and was instrumental in establishing this lecture. Today's lecture is also part of our Racial Justice Speaker Series, which is now in its second year. Created in response to the tragedy and the tragic killings by police of George Floyd, Breonna Taylor, and others, the series explores the origins and impacts of systemic racism as it affects all of our communities of color in all areas of law. Now, our speaker today, Danielle Citron, is the Jefferson Scholars Foundation Schenck Distinguished Professor in Law at the University of Virginia. She writes and teaches about privacy, free expression, and civil rights. Her scholarship and advocacy brought national and international recognition. In 2019, Professor Citron was named a MacArthur Fellow based on her work on cyberstalking and intimate privacy. And she tells me that she's going to frighten us a little bit more today in talking about privacy. Professor Citron's book, Hate Crimes in Cyberspace, published in 2014 by Harvard University Press, was praised by reviewers. She's published in leading journals in the country, and she's won too many awards for me to mention today. Now, her talk is titled Intimate Privacy, a Civil Right. That's also the title of her forthcoming book from W.W. Norton and Penguin Vintage UK. Please welcome Professor Danielle Citron.
Thank you so much, Dean Johnson. Thank you so much, Kelly, for having me. I so appreciate the chance to talk to all of you. And so my book that's going to come out this summer actually has a new title, which is The Fight for Privacy, Protecting Dignity, Identity, and Love in the Digital Age. So hopefully the title will be self-explanatory after we talk a bit about intimate privacy, what it is, why it matters, why we should conceptualize it as a civil right. And I'm going to try to focus my remarks, just given the wonderful endowment by the McClatchy family, on the way in which and the ties between intimate privacy and free expression. And then as I talk about what law can and should do to honor intimate privacy as a civil right, I'm going to talk about the famous Section 230, which is, it's the criticisms of Section 230 are all the rage. And I'm imagining our audience might want me to talk a bit about it and how we might reform it in ways that don't undermine free expression, or at least recognize the trade-offs, but have an appreciation for some of the retention of Section 230, but with its reform. Okay, so let me describe or define for us what I mean by intimate privacy. And then I'll talk a bit about why it matters and how, especially vis-a-vis individuals and companies, our intimate privacy is being denied and violated. So what I mean by the term intimate privacy is the privacy that is afforded us around, allows us to manage the boundaries around our intimate lives. So it's the privacy, that it's access to and information about our bodies, our minds, our health, our sex, sexuality, and gender, and our close relationships. And intimate privacy covers kind of all of our on and offline interactions, our activities, our communications, our searches. So it's all the ways in which we communicate and engage with others on and offline. It's a descriptive and a normative concept. Intimate privacy is a precondition to a life of meaning. And so it's fundamentally a moral concept. So let's just, I'm going to underscore some reasons why intimate privacy is what I understand and will argue as a foundational privacy interest. That is, that we have lots of different types of privacy. Some privacy matters more than others. And at the heart or center, a foundational value is the privacy afforded as it interlocks with intimacy and intimate life. So now the privacy around our intimate lives is essential for us to develop our sense of authentic identity, right? So our bodies are our first form of reference for our ability to develop who we are. It's through our bodies that we come to know ourselves, and time alone with our bodies and inviting others involved in our lives helps us figure out who we are and what our future selves will look like. And it's the ability to decide who has access to information about our bodies, our health, our minds, that provides the basis for both self-respect and the social bases of respect. So dignity understood in that way, that when we decide for ourselves and can set boundaries that are respected around our intimate lives, we have a sense of self-esteem, right? That we're making these choices about who has access to our bodies and our intimate information. And when we can be seen as fully integrated people, right, rather than just fragments of ourselves, then we can enjoy the social bases of esteem. And privacy is the precondition to love. That is, it's an essential ingredient to love and close relationships. So when we come to know others in close and intimate ways, it's through a process of mutual self-revelation. And it's only when we can only really make ourselves vulnerable to other people if we trust that they will keep what we share with them, our most intimate selves, sort of like peeling back as we do like an onion, our most sacred selves. We're only going to do that if we think that our loved ones are going to treat our intimate information as we hope rather than as we fear. And so once we can do that, right, the integrity of the relationship can evolve when we have a sense that those with whom we care about, right, it does not necessarily our partners, right, our intimate partners, also close friends, our close family members, people who we trust. That is, trust and discretion are so essential to the development of any close relationship. And so intimate privacy is implicated in all sorts of ways, right? It's implicated when we go into a dressing room and we take off our clothes, like, we're trying on clothing, or we're taking a shower in a gym locker room. Intimate privacy is what we expect, right? Intimate privacy is the kinds of privacy around our intimate lives that we want, that we expect, and that we deserve, right? So intimate privacy, when we share a nude photo with a loved one, intimate privacy is the kind of privacy that we expect, that we deserve in those nude photos. It's when we use a dating app, right? The privacy that when we're sharing our information about our sexual orientation, our fantasies, nude photos of ourselves that we're going to share with others on the site. It's the intimate privacy that we want and that we deserve. So let me give you a sense. So that's the kind of the normative story, why we should care about intimate privacy. And I'm going to talk a little bit about privacy's denial by individuals and by companies, and then talk about what it is that we risk, right? And I'm going to emphasize some of the harms to our capability and our desire for free expression. And then talk a bit about why we should conceptualize intimate privacy as a civil right and what that might mean for our guardians of our civil rights. Okay, so individuals, they invade each other's intimate privacy for all sorts of reasons, right? For power, for sport, for social approval, and for really, frankly, no reason at all. And they do it in various ways, right? So I'm just going to give you a few examples of the ways in which individuals violate each other's intimate privacy. And the first is video voyeurism, right? The hidden camera that tapes you in the bedroom, the bathroom, in ways that are non-consensual, right? In South Korea, the prospect of going to the bathroom, a public bathroom for women, is fraught with danger because video voyeurism is so common that women either don't go to the public restrooms or they bring little kits so that they can find holes in a bathroom and fill them in with silicone. So video voyeurism. Next are upskirt and down blouse photos. So you're riding a subway, someone holds a camera underneath your skirt to take your photo of your undergarments, or you're walking in a store and someone uses a hidden camera, like there are sneaker hidden cameras that allow people to take photos up your skirt that you haven't permitted, right? Another illustration of video voyeurism is the upskirt and down blouse photo. Then there's something called sextortion, which is when you obtain someone's nude images, whether you have coaxed them into sharing it with you or you've taken it without permission, as in video voyeurism, they then use that image and demand other nude images or for someone to perform sex acts, let's say on a video cam, on the threat that if you don't do these things for me, if you don't share my nude images, then I'm going to post them online. And so sextortion is that process of, it's sort of the new school version of extortion and blackmail, which is you get someone to send you nude images on the threat that they will otherwise be posted. Sextortion. Then there's non-consensual intimate imagery, which is the posting of someone's or sharing of someone's nude photos or intimate images without their permission. And I'm just giving you some illustrations that are really common of ways in which we violate each other's intimate privacy. And then the newest, or among the newest examples, is deepfake sex videos, right? That's when people's faces are swapped into porn without their permission. There are about 60,000 deepfake videos online. About 96% of them are deepfake sex videos, and 99% of those sort of fake porn are of women's faces being inserted into porn without their permission. And it's not just celebrities, though that's quite common, though it's everyday individuals as well. Now, for the most part, for invasions of intimate privacy, and I suppose this will not be shocking, is that the majority of individuals who are targeted are women, women of color, gay, bi, trans women, and gay and bisexual and trans men. So you've got, so often it's disproportionate. In some countries, the disabled are included in disproportionately who's targeted. You've got really the most vulnerable among us, right, are being targeted with online abuse. And there are sites, they're hosted in the United States for reasons I will explain and get into, but there are over 9,500 websites devoted to the display of intimate images, either taken, these sites are so uncreative in their names like the Candid Forum or Candid Camera, right? But what they do is, they solicit users to submit or to post themselves intimate images, and some are subscription based. Many are, they make money from collecting, mining, and sharing people's users and subscribers' information, and the advertising model. Now, the reason why they can do this is Section 230 of the Decency Act that I'm going to talk a bit about, is what provides an immunity to platforms, content platforms, for user-generated content. And so they're shielded from liability for what their users are doing. And therefore, they can make money, they can exploit people's nude images, and they could say, too bad, so sad, right? There's nothing we can do. Okay, so that's the ways in which individuals invade each other's intimate privacy. Now, companies are amassing and collecting our intimate information as well. Now, they're not doing it because they care about us as individuals, right? They're collecting, using, and sharing, exploiting information about our intimate lives because that's the business model, right? And particularly, I feel like the United States is a scofflaw in all sorts of ways. Thanks to 230, it's a scofflaw in enabling invasions of intimate privacy with no cost to the enablers. And for companies, because the United States lacks a comprehensive and rigorous data protection law, companies can basically, if you don't lie to us, and you provide notice in a privacy policy hidden on a website, you can basically collect intimate information to your heart's content, right? If you're a company. And so I'm going to give you some examples of first party, that is sites that and apps and services that we know about, that we deal with, that are busy amassing our personal, our intimate information. And then third parties, that is, what does the sale of this information look like? So just going to take three examples. The first is the femtech market, right? So 1/4 of all women and girls in the United States basically use some form of either a fitness band, a period tracking app, or a fertility app. And so these apps are collecting, and then I'll explain, using and sharing information. It's not just about, let's just take a period tracking app, not just about when your last period was and your physical symptoms, but also, and they require users often to provide an extraordinary amount of personal information, almost as part of the process, that you can't avoid submitting this information, including when you last had sex, did you orgasm, who did you have sex with, if you have drug and alcohol addictions and other health problems. So they collect not just information about the sort of mucus secretions, I hate to be specific, but that's, they're collecting very specific information about women's bodies with regard to their fertility, but also incredibly invasive and intimate information about their sex lives in ways that seem like a game. Like the entire project of these apps, if you look at them, is like they're gamifying it. It's like, woohoo, with pretty colors and balloons. And the idea is like, it's called, Penelope Phillip calls it seductive surveillance, right? They're sort of nudging us to share more and more about our intimate lives. Then there, of course, they're dating apps, right? They're collecting information about our HIV status, our sexual orientations, the kinds of sexual activity we're interested in. And lastly, just as a third example, are the home devices. So the Amazon's Alexa you bring into your kitchen, Amazon's marketing a device for your bathroom called the Flex. And the goal is to be in every room of your house. And what happens is they're on all of the time and collecting information. And they don't just wake with the wake words like, hey, Alexa, hey, Siri, right? They also wake. They have high false positive rates. And so they're recording information about, and there have been whistleblowers that have so disclosed that they're capturing recordings of people having sex, of discussing their drug prescriptions, and other ways in which unanticipated sort of surveillance of our intimate lives. And those are the companies we deal with, where we think, okay, I bought an Alexa, I understand that it's in my kitchen. But there are, we call them third parties, and that sort of masks their perniciousness, but there are parties, entities, firms that we have no relationship with, right? But that are busy amassing profiles about us. And that's the advertising and marketing. First, we call it the ad tech industrial complex for a reason. Its tentacles are everywhere. So you might think, come on, there's some things that are just so sensitive. Marketing firms and advertising firms aren't, right? They're not tracking us. And you think, okay, adult sites or porn sites, isn't that the kind of thing that we don't think they're trackers, right? Well, for 99% of sites, of adult sites, there are at least 7 companies, advertising and marketing firms, gathering information about the videos you're searching, the types of videos you watch, how long you watch them for, and they're including all of that information in advertising profiles. Same is true with mental health apps. You might think, well, gosh, no chance, no how. Like that they're amassing and selling information of what we're sharing with our drug addictions, our health problems. They are as well. And then data brokers, right? The sort of secretive and shady. This is Congressman Ron Wyden has described the data broker industry, about 4,000 companies that are amassing profiles with at least 11,000 data points on each and every one of us. They're buying information from the advertising marketing ecosystem and including it in profiles about each and every one of us. Some of their biggest clients are the government. So Big Brother has little helpers, as Chris Hoofnagel sort of brilliantly called it many years ago, but also, of course, other companies. And they will tag into, so what are these 11,000 data points? Like, how is it that each and every one of us has 11 data points about us? So we're tagged as rape sufferers, sex toy users, likely, so they're health data brokers whose raison d'etre is to like predict the kind of health problems we're going to have, including our percentage and likelihood of becoming type 2 diabetic. Imagine all the ways in which really sensitive information is being not only collected about us, including in profiles, but used to make predictions, right, to score and rank and rate us. So those are just some examples of companies and individuals who are invading our intimate privacy. So I'm going to just give you two examples just to bring alive this issue so you can sort of, as I always do, like ground them in real experiences. So Joan had a newly minted professional. She traveled for work to a New York hotel. And while she was there, unbeknownst to her, and what we believe is a hotel employee, planted a camera in the bathroom, both in the shower and then in the bathroom. She returns home from her trip and she gets an email that says, click on the link and you'll see the videos I took of you showering and going to the restroom. She clicked on the link and sees that it's of her showering. And the sender of the email says to her, send me more material or I'm going to send these to your colleagues, both at work and then all of your grad school, people from grad school, which got all of that information was easily gotten by the sender on LinkedIn. Now, so the individual lets me know, I say, you're not sharing with that information, you're obviously not going to be sextorted. And immediately after she says no, the videos are sent by email to all of her LinkedIn contacts, including her grad school friends and her colleagues at work, and then posted on adult sites, including Pornhub and countless other adult sites and adult finder sites, along with her name, identifying information and address. And as soon as she, let's say a site like Pornhub actually helped her on various occasions take down the videos, she would then receive emails from the sender taunting her, saying, I saw that you took it down, another one's going up. And it was sort of a cycle that didn't end for a good 6 months. Okay, so that's I'll call her Joan example. Grindr is a gay bi men's, dating website, app. And it encourages people to post their HIV status. And doctors were incredibly enthusiastic about the development because it would nudge people to have conversations about safe sex. The Wall Street Journal did an expose 2 years ago in which it explained that users' information, their HIV status, the sort of subgroup that people identified with, and other intimate information was being shared with marketers and advertisers. And in response, individuals speaking to the press explained that they weren't going to share their HIV status with anyone anymore because they were terrified of discrimination, and that they assumed that Grindr wasn't sharing that information with marketers and advertisers who could then sell it with data brokers, because of course it's a community which anticipates the possibility of discrimination. So those are different types of violations of the intimate privacy that we want, that we expect, and that we deserve, right? So let me just underscore a bit about the harm that individuals suffer and tie it to free expression, right? So Joan, as she explained her response to the invasions of intimate privacy, explained it just fundamentally changed how she moved through the world. She, in her relationships, it was incredibly costly. She sort of shrank from others, ways in which she felt free to create relationships and friendships. She felt like the aperture of her life had shrunk, that she was afraid to share confidences with individuals. What if they took advantage of her, right? Her sense of trust and safety and faith in others shrank considerably. She withdrew and shut down all of her social media platforms, all of her profiles, including LinkedIn. And what she explained to me, and this is true, I interviewed more than 60 people in connection with my book, individual victims of intimate privacy. And so often what resonates is the idea that individuals feel like they can't express themselves, but they have to shut down their social media information because their attackers can leverage it against them, and that they don't want to open themselves up even further to more abuse. And something that Joan explained to me is that the idea that she had to shut down her Facebook page was so painful because that is where she formed so many close relationships, right? Her high school friends, like all the ways in which she used social media for self-expression and for community engagement, right? And the Cyber Civil Rights Initiative, we've done studies about the ways in which, and researchers in Australia, as well as researchers in the US, have found that victims of intimate privacy violations, they withdraw from online life, right? They withdraw from all the ways that they once connected with people. They do it not because they want to, but because they feel they have to protect themselves. And the same is true in the Grindr case, right? So many individuals, after they learned that Grindr was sharing their HIV status with advertisers and marketers, explained that they were going to take down their HIV status because they feared that their expression would cost them, right? And so the sort of direct connection of intimate privacy with self-expression and all the ways that we connect with others, as well as, of course, the connection to equality, because so often the victims of intimate privacy violations are women and minorities. And at the same time, the ways in which information about the body and sex is going to more often count against and hurt women and people of color and sexual and gender minorities, right? That we often discuss, have a sense that I'm going to borrow from Martha Nussbaum now, that is like bodily fluids are something that provokes just feelings of disgust. And that's especially true for women and sexual and gender minorities. And so all of this intimate information is going to be more costly too, of the speech and expression, as well as the economic opportunities of women and marginalized people. So, okay, now what do we do? I have conceived of intimate privacy as a right that we all deserve. That is, it should be secured to everyone. But we ought to understand it as a civil right in the early tradition of the way in which we talked about civil rights, which was from the late 1800s, like the Civil Rights Act of 1866, really until the mid 1950s, which was the idea of having both a civil right, which is a right that was fundamental for self-development and human flourishing that everyone enjoys, and that right that should be particularly protected against discrimination. And so I make the case in my book that intimate privacy is a necessary condition of dignity, of identity development, intimacy, and equality, that each and every one of us deserves intimate privacy. And in particular, who it most is cost when it's denied are women and marginalized people. So we need to have anti-discrimination commitments. Now, when we think of civil rights, right, there are parties that we think are of the guardians of those rights. So, and often they're the folks in control or power over physical spaces. So our schools, our public accommodations, our voting booths, right? There are physical places. Well, we ought to really, we should be thinking about guardianship duties of our virtual spaces. And so that brings us to Section 230, which is the law that immunizes online platforms from liability for user-generated content. Now, I've proposed that we ought to think about platforms as the guardians of our intimate privacy with special responsibilities, and in particular to take, and I've argued, reasonable steps to address illegality that causes serious harm. Now, some of my proposals over the years were sort of viewed as off the wall. The very idea that we might change Section 230 was like a non-starter 15 years ago. And now Section 230 is sort of under assault, but for reasons that are both like a misunderstanding of what it does. And I'd like us to think about reform, keeping Section 230, but reforming it and conditioning it on reasonable practices in the face of illegality. It would bring the law back to its original interpretation, which was in the title of the provision. It's called Good Samaritan Blocking and Filtering of Offensive Speech. So that platforms acted responsibly, right? Protected our rights, our intimate privacy and free expression. And one of the arguments against my proposal is that we're going to see the chilling of speech. But the truth of the matter is that the status quo, like doing nothing and keeping Section 230 as it is, that chills speech. We know, and we have proof, right, that women and minorities go offline, that they change their self-expression, right? They become less engaged with their communities. That's something we need for democratic citizenship, because they face intimate privacy violations and cyber stalking and online abuse that chases them offline. So we know the speech costs of doing nothing, right? And so we need reform for Section 230 in order to enable them to speak, that is victims of intimate privacy violations. Law can free us to speak in that respect. So I think my time is up, but I'm so looking forward to your questions. And I feel like I had such little time to talk about my book, but so I'm so looking forward to any questions that you have about intimate privacy laws, inadequacy, how we ought to fix law, and really anything. Kelly, I know that you're manning the questions for us, so hopefully folks have asked questions.
Yes, yeah. So I do have a question, and I invite anyone to send those to me through the chat so I can ask those. But I'm going to start with a question from Audrey. And she says, please contrast our current legal framework with that in other countries, particularly the EU, Canada, and other Western locations.
So conceptualize, great question, and will be a big sort of part of my book, because I talk about the sort of global challenges to intimate privacy. And conceiving intimate privacy as a civil right would certainly bring us closer to the European and sort of there are like 70 countries that view privacy as a fundamental human right. Right. And so the concept is similar in the sense of understanding intimate privacy or privacy as a fundamental right, as a human right that's afforded special protections that would be balanced against understanding that privacy can be essential for free speech, but also balanced against when it can clash with free speech on a sort of proportionality basis. And the interesting thing about the EU is that you might think, okay, it's viewed as a human right, so there's robust substantive protections for intimate privacy. But the cash out in the European and then other countries' data protection laws actually not as far removed from our approach, which is in the United States, we have a very procedural protections, very weak protections for privacy, which involve giving notice, right, and presumed consent. Now, the EU's GDPR, right, they conceptualize privacy as a human right, but the cash out is still pretty weak, right? It's stronger than our procedural protections, right? But they're still procedural. So that's why, May 2018, you got 1 million emails from companies asking you to give your express consent for the collection of your information. Now, what the GDPR requires is giving us the ability to say no, right? But the premise of GDPR is still procedural protections and not substantive ones. And so in my book, I urge Europe, they do a great job talking about human rights, but they're not putting their money where their mouth is in terms of their regulatory commitments, and we need much more stronger substantive commitments.
I think that actually is a good segue into another question that is, should Congress pass a federal law to protect intimate privacy,
Yep.
or should states?
Yes. So in two important ways, we need Congress to step in, right? The first is a comprehensive. So I've been working on Capitol Hill. We have a federal bill, but it's quite narrow. It would protect would provide criminal penalties for the non-consensual posting of intimate images, right? And I think, and I've been arguing, that we need a more comprehensive criminal law that covers all forms of violations of intimate privacy, right? The time is now not just to think about the ways in which we use the internet to post nude images, but video voyeurism, sextortion, right? We need a comprehensive approach. So we do have a federal bill, but it's worth kind of expanding. But crucially important is the story about companies, right? We need comprehensive reform at the federal level that we could see supplements, of course, at the state level, but we need robust protections that treat companies as the guardians of our intimate information. So we need strong limits on the collection of intimate information. We need duties of care, of loyalty, of discretion and confidentiality. That is substantive duties that companies owe us if they're going to protect our intimate information. I don't want to get rid of these tools, right? I want us to use them and have them honor our intimate privacy as we want, as we expect, and as we deserve. And so, yes, we need a federal comprehensive data protection law that's substantive in nature, that's robust and rigorous in its protection, and that treats companies as the guardians of our intimate information. I'd love a federal bill on the criminal side that's more comprehensive. But I've been my approach is very much has a civil bent. We have so many pathologies with the criminal system that I worry that, like, unless we fix those pathologies, we're going to end up, and I've seen this in my own work, who faces criminal penalties. What's interesting, and it's not because they're more often the perpetrators, but we only go after the perpetrators if they're female or they're Black and brown when it comes to violations of intimate privacy. So, like, we got to fix a lot of the problems with our criminal system, which I suppose is par for the course of the wonderful discussions that you've been having here as part of this lecture series.
A question about one of the examples that you gave. Did the hotel victim have any criminal or civil recourse under existing law? Was it federal or state, maybe both or none?
Totally. Great question. So when Joan took her experience to state law enforcement, she was told, like, get over yourself, just ignore it, it will go away, right? And then she went to the FBI, and that's where I have lots of relationships. And so she went to federal law enforcers, and despite the fact that I knew the prosecutor, I didn't know the agents, but it, as she explained to me, part of the response to her was like a suspicion that she took the videos herself, right? The sort of blaming the victim on steroids. And she was, devastated by that suggestion, but provided evidence. Like, she was much more had documentation of an attempt to figure out who the sender was, right? And the bottom line is, at the end of the day, the FBI basically let the case fall by the wayside because they said they couldn't find the perpetrator. Okay, so that to us was more of a will problem, that is a desire and a resources problem, than it was the actual inability to find the perpetrator. Now, the question, right, also was about the ways in which are there civil claims too, right? I took the question to be not only about the criminal sphere, but also sort of civil remedies. Now, because there was a deep pocket, right? Like, in most cases, you can't sue Pornhub, you can't sue the platforms. Can you sue the hotel? And so that case is ongoing. That is the suing the hotel for negligent hiring, right? Is a lawsuit that's ongoing, but she couldn't sue the platform. She couldn't sue all of the adult sites that hosted the photos that refused to take them down because of Section 230.
Okay. Looking at everything that you've detailed and outlined for us, one of the questions is about what we can do. And hearing everything you've said, How careful should we be about the websites we're visiting, we're subscribing to, we're buying products from? What is your advice there?
So what's hard is that there's very little in terms of like self-help that we can do. That is, if you want to use a period tracking app, right? Um, they're going to ask you for your information, and unfortunately, they may not allow you not to give that information. That is, like, there are sort of screens that you have to fill out for you to sort of to get in, to take advantage of the products and services. That in some respect, it's part of the deal, right? Is providing your information. Now, you could not use those services, but I hate saying that. I don't want to be that person that's like, because that's not the way we should live in the 21st century. I want you to get the most out of these tools. I don't have an Alexa, right? Like, there's some things where I say, like, drawing the line, like, no chance, no how, because it's too fraught with concern. But I feel like I can't say to young people, don't use dating apps, right? We need to press for reform, right? And so what we can do is join advocacy efforts. So I'm the vice president of the Cyber Civil Rights Initiative. We press for change at the federal and state level around privacy laws. Yes, we can try to, use encrypted apps. When you communicate, use Signal, but it doesn't protect you from a lover betraying your trust, right? So what's hard is the response often to victims is to blame you. And especially when the victim is a woman or a minority. And that is the most devastating part, right? Is they've done nothing wrong, right? But trust either companies or individuals in ways that they want, expect, and deserve privacy. And so there are some small steps that we can take, but unless you want to completely opt out of online life, it's really hard, right, to prevent the tracking, scoring, and ranking and rating of your information.
Can you talk more about the differences you see in how minorities are treated in these cases? And what do you think is responsible for that?
So there's a long history, of course, of gendered harms and harms suffered by individuals who are sexual gender minorities, as well as like racial minorities, that we just don't take their harms seriously. We have a massive over-incarceration problem, but truth be told, when it comes to cyber stalking and in violations of intimate privacy, we don't have an over-incarceration problem. We have an under-enforcement of a law problem. So law enforcement will just dismiss individuals, say, get over yourself. One law enforcement officer said to a victim who I counseled, who's a Black woman, and they said, you should be flattered that someone posted your nude photo online. It's like being told you're fabulous masturbatory material. Like, aren't you flattered? So unfortunately, there are statistics from across the globe that individuals who are targeted are more often women, gender and sexual minorities, and racial minorities, as well as disabled individuals. And that more often, and this is a global problem, that law enforcement, the response is basically get over yourself. So famous case of a deep fake sex video from India, Rana Ayyub's journalist. She's a Muslim journalist in India who was very critical of the Modi regime. After she did a BBC interview in which she criticized Modi, that was like a bridge too far, a deep fake sex video appeared of her, and it went viral. It was on like half of the phones in India within 48 hours. She had gotten a tip off that this was happening from her source inside the Modi regime, said, check, see what's happening, right? It was clearly a threat to shut her up. When she went to police in Delhi, the response was like, it's just boys being boys. Sorry, nothing we can do. So it's not as if this is like a uniquely US-centric problem, right? We see it in Australia. I work closely with the South Korean government. That is, we see the problem of trivialization, especially when it comes to gendered and racialized harms. It's a prevalent problem across the globe.
James asks, how do you propose resolving the issue of internet anonymity? It seems to be a challenge for arguing or prosecuting cyber abuse.
What's so interesting is that, so throughout my career, my first book was about cyber stalking, and this next book is about violations of intimate privacy. So often the response to me is like, isn't anonymity the source of all of these problems, right? That is, if we had to sort of post in our real names, that people will behave themselves. And the truth of the matter, there's a ton of research on this, that no, that even when we post in our real names, even when we know that we're subject to being identified online, we still act destructively. Right. It's in part because of de-individuation, that feeling behind the screen, that we don't see the people we're hurting. We don't see their facial expressions, right, and the pain that they're suffering. And so we're more willing to engage in it, even if we're posting in our real names, right? I know we can get caught. Now, what's interesting, then there's the other side of it, which is the question about law enforcement, right? Like, online anonymity can make it difficult to find perpetrators. And that's certainly true. We saw that was the excuse in Jones' case, like, to not pursue the matter. But we've never lived in an age we've never had more information about people online. We live in a golden age of data surveillance, right? And so with enough resources, and particularly we certainly see this, that they have got huge resources and technical expertise and chops at the FBI, like, you can pretty much, if you have the will and desire to put resources behind it, you can figure out who perpetrators are. Sometimes the question is more jurisdiction, like, do they live in the United States and can we grab them? Right? We can't if they're outside the United States. And so often, police will play jurisdictional hot potato, where a victim is from state A, the victim is perpetrator is state B, victim goes to state A law enforcement and says, like, this is happening, it's my ex, he lives in a different state. State A says, look to state B sends them back to state A. It's like no one wants to deal with it, right? And so the problem is less having to do with anonymity, and then it has to do with will, right, and interest.
A question about how we should be talking about intimate privacy, with our loved ones. What should I tell one of my adult children about using a dating website? This person says, I know that I would tell my adult friends not to use them unless they want all that information shared with the world. But what about that position you're in as a parent, talking to your children?
Yep. And so if I may answer the question both as, and I have a parent of 2 young adult girls, so I feel this problem deeply, right? But I want to answer both as to companies and then as to individual perpetrators, right? Because the first thing, right, is with companies, the difficulty we have when we talk to young people is, like, can't tell them not to participate in tools that are sort of essential for life, right, in the 21st century. And so at least I don't tell my kids they can't use them, right? Because I warn them about sort of physical dangers. I work with Bumble on their safety processes, right? Like, there are ways in which these companies can do so much better, and they shouldn't be selling our intimate information. I just am loath to say to young people, forget sexual expression and dating in the digital age, like, we're going to lock you in a box. And I feel like I can't give that advice to my own kids, right? I don't want to give it to yours, but at the same time, when we think about our responsibilities to ourselves and to others, what I would like you to talk about with your kids, even if they're in high school or middle school, is the way in which we should protect each other's intimate privacy, right? That is, respecting others' confidences and being discreet with others, whether it's nude photos or information that someone shared in confidence. That is, trust is at the heart of all of this, right? And so I would love to see many more. Education is such a key part of this, right? Well, moral suasion is key, because we got to get companies to change their ways. Law moves slowly. It's a blunt instrument. I'd love to change the law tomorrow, but right now, what we can do today is what we can do today, right? Is talking about education and moral suasion vis-a-vis companies. And I would love to see much more education to young people about their responsibilities to each other, right? About respecting each other's intimate privacy, understanding its value for identity development, for dignity, for life of meaning and love, that it has to be a first priority in how we treat one another.
Another question, just going, let's keep this thread going, about if people decide to use these dating sites, and let's say young adults, as they go on, they start careers maybe 10, 20 years later, are you finding that these things follow them, that they could interfere with their professional lives?
Yep. And that's the biggest problem, right? Is we live in an era of persistent memory, right? And so when you've been a victim of an individual attack, right? If it's in a Google search of your name, it's incredibly destructive no matter how long it is, right? If it remains in a Google search of your name, then intimate information can be destructive to the jobs you can get, the interviews that that you have available to you. That is, it's going to have economic consequences that are as long as the information stays up, right? And the difficult part about companies, that is the kinds of information that advertisers, marketers, and data brokers are collecting about it, is that the whole thing is opaque, right? And so all that information, there's a long tail of risk that each and every one of us can't really identify, because there's a job you didn't know you weren't eligible for, right? You sent your resume to, to a black hole. You don't know why you don't get that job. And it very much could be intimate information that's being algorithmically sorted, ranked, rated, and we just don't know, right? And that's some of the difficulty. That's why I suppose I want companies to act as data guardians, right? To not adopt technologies, right, before they have proof of concept. They need a really good reason to implicate and violate our right to intimate privacy. And if they don't, they shouldn't be doing it, right? They shouldn't be collecting, using, and sharing our intimate information. Like, almost need a total shift in how companies and individuals treat each other's intimate information. And it's only until we have that shift that we cut down on the intimate information that's collected, used, and shared, because so much of the risk, the long tail of risk, whether it's your job opportunities, your health insurance premiums, like we can't discover those risks because they're all bound up in black box systems, automated, decision systems. So we can't know the basis of the decision, and we'll never know what we didn't get, like the opportunities we never got, the insurance premiums that are quite high that we don't understand why, right? We can't get at the underlying explanation.
So there's so much we won't know about the ramifications of these things. But what about when you do know, when a potential employer or someone says, hey, I found this out about you? I mean, how do people respond to that? What do you advise in that situation?
Right. So, I mean, there may, in fact, so let's say you find out an employer, this happens all the time to victims of intimate privacy violations, which is like, we thought you were great, but we did a Google search, and we can't have clients interacting with you, right? Or we can't hire you because we think you're awesome, but we can't take the risk, right? And that happens all of the time to victims, right? Now, is there a possibility or a basis for a lawsuit under Title VII? Sure, there may be, right? But it's a tough row, like it's a tough thing to prove under Title VII, intentional discrimination.
Mhm.
And so the law is, in some sense, really fails us in this capacity, right? And that's why we need anti-discrimination. We need comprehensive protections that will protect against discrimination in ways that are robust, right? So we need to fix the laws too. And that has a lot to do with the protections in Title VII and other ways in which, when you find out, the employer says, like, too bad, so sad, I looked in Google and it's not good for you, right? Like, the nude photos make you look, they just aren't good for us. We can't hire you. We think you're great. We don't even think you shared them voluntarily, right? Like, it's not your fault, but sorry, which is so often what victims hear. Our current laws aren't enough of a disincentive for them to not only say that, but to do it, right? To deny you those opportunities. And we need, in some respects, many robust commitments to anti-discrimination that are more robust than we have now.
We have our final question here. And this, I think, is a good way to look forward and what we can expect in the future around this issue. But Celia writes, do you think that law enforcement treatment of violations of intimate privacy will be like the treatment of rape or stalking, and that perhaps with education that it will evolve and victims will not be blamed and their experiences will not be dismissed.
Yep. And that's precisely what I have been working on. Educating law enforcement. I worked when she was the AG of California. I worked closely with AG Harris for 2 years on her, both the training of law enforcement vis-a-vis what she calls cyber exploitation, the posting of nude images. And so it's a long road, but absolutely, like much in the way that we see the cyber stalking trivialized, and that's more often women and minorities who are the victims. We need to educate law enforcement, right? And that we see it with sexual assault, right? We see it with cyber stalking, we see it with intimate privacy violations. So absolutely, right? We need to do a better job educating law enforcement.
Thank you.
Those are great questions. And Kelly, we're so seamless in how you ask them. You have an art to this.
Oh,
you have it down pat.
Thank you.
So thank you so much for having me.
Well, thank you. Thank you for your wonderful talk, and thanks everybody for being here. And I look forward to seeing the new book. Take good
Yes.
care, everybody.
Thank you. Thank you so much, everyone.